Hi, welcome to Legal Tech Diaries. As you know, my videos are split into two parts. First, we discuss the legal side of the topic, and then we shift into legal tech side to see how it functions in modern legal practice. Today, we're going to talk about one of the foundational topics of contract law, the consideration. We will look at what constitutes to a valid consideration and when it may fail. Let's start with the definition. Consideration is defined as an act or forbearance of a one party or promise thereof, which is the price for which the promise of the other is bought. This principle would be very good seen in the case of Carlo pneumatic tire versus Selfridge. In this case, the Dunlop has an agreement with another company, the distributor, which in which the agreement stated that the tires should not be sold below X price. Then the distributor has resold it to a Selfridge, and the Selfridge sold the tires with a price below what has been agreed between the two. In this case, then the Dunlop has sued the Selfridge. The court has decided that there is no consideration, so the parties were not bound with each other, as the Selfridge was not a part of the consideration, and the consideration should move from promisee, and in this case the promisee was not a Selfridge. So this states once again that the parties should have a consideration, and you cannot sue anybody who is not in your contract, so outside of your contract. So let's now talk about the gratuitous promise if it's legally binding. So if it's a gratuitous promise, so it is informally and could not be enforceable unless it is formalized by being made with seal, or it can be made as refers as a being made by deed, or it would be supported with consideration. So in this case, if there is no formal consideration, then promise there could not be it could not be enforceable. For example, if your friend promised you to give his laptop and you're not going to give something back, and after that your friend changed his mind and didn't give you the laptop. In this case, there is no contract, and in this case, there is no consideration because it was done not officially, it was not enforceable and an informal promise. We distinguish two forms of consideration, executed and executory. Executory consideration is a promise of the parties to exchange. And it is so that an example would be when for the future. So again, it is the promise of exchanging for the future. And the example for that is when one side, the seller is selling the goods and they decided to make a delivery for the future date. And the buyer decided to promise to pay upon delivery. So in this case, this is executory consideration. Executed consideration is when one party makes a promise, and this promise is performing an act and this is in response to promise. An example would be, for example, an A promises to wash the windows, and the B promises to pay 50 euros for it. When the A washes the windows, the promise would be executed. But if it's not washed, the windows, then the B is not legally binding and there is no need for him to pay for that. Now let's shortly talk about the past consideration. What is a past consideration? It is a consideration which has been done when the contract, an agreement has been completed. For example, when you promise to pay when the other party has already performed the act. But this is not in the cases when there is already an agreement between two that it would be paid after the act has been performed. This is called a past consideration, and it is seen in the case between the Ross color versus Thomas. The woman has bought a horse, and this horse was the contract was completed, and after that Thomas assures that the horse is not in a good state. The woman has sued, and the court held that it was a past consideration because the contract has already been completed. Of course, there are exceptions when there is not the past consideration is not functioning. First of all, it would be when the promiser has requested it. The second one would be then there is no explicit stated at that time, but there are expectations that it would be a payment or it would be benefits. And the third one, when the all usual elements of the legal contract exist. So now let's talk about the adequacy of the consideration. The consideration should not be adequate, but it should meet the minimum low value. That means that it should not match with the market value. And if in the eyes of the law this is sufficient, then it would be a sufficient consideration. A sufficient consideration example is when there are a lot of examples, but sufficient consideration is something that as such should not be adequate. And one of the principles established is in the case of the Nestle versus Chapel. And in this case, the Nestle has requested £1, 6 shillings, and three chocolate wrappers to buy a record. So everybody who was sending that could participate and receive the record and buy the record. It was a question if the 3 chocolate wraps are adequate and are part of the consideration. The court held that yes, this could be a part of consideration, and it should not be an adequate value, and in this case it was decided that together with the payment it is sufficient consideration. But of course there are some examples where where there is no sufficient consideration. It could be in examples of the moral obligations, the law and affection. And here we can see in the case Thomas between Thomas. So Thomas has written in his will that he wants that after his death, his wife would stay at the house. The executors respected and let the woman to stay at home, and she was paying yearly €1 rent. Then they sued, and based on the fact that the respect is not sufficient consideration. The court held that love and respect are not a sufficient consideration, but €1 rent is totally a consideration which could be sufficient, and this would be legally binding. So we have reached the part of the legal tag, and now let's see how the consideration could be automated in legal tag. So taking into account the contract lifecycle management platforms, the systems can tag the contract. So for example, when it is an offer, or when it is the performance, it can tag if the consideration is a past consideration, it is executed or executor, and it would help to check the compliance of the consideration. Secondly, it can detect the words like gift or moral obligations which are not sufficient, and in this case it can flag the words in the contract, in the offer, and it can add a comment. And in this comment would be written, for example, this consideration, this should be converted to promise into deed, and it is a weak consideration, or it can add a comment that there is a need for a minimum pay, so it would be legally binding. So this detection of the words would be very useful when it is draft, and not only when it is also in the review process of the document. They would bring more information and help to detect the consideration. So that's all for today's video. Thank you, and see you in the next episode.